Hold on, hold on real quick.
Mayor?
Yes, pleasure, sir. Hey. He'll be right with you. All right, thank you. Sorry about that. At this point, I'd like to open up the Baldwin Park City Council special meeting. Today is March 4th, 2019, and the time is 6:11. At this point, I will ask, excuse me, let me just go through the actual process real quick. So, okay, so at this point, we'll ask our city clerk to conduct roll call.
Thank you. Councilmember Alejandra Avila. Here. Councilmember Paul Hernandez.
Present.
Councilmember Ricardo Pacheco.
Present.
Mayor Pro Tem Monica Garcia.
Here.
And Mayor Manuel Lozano.
Present. All right. Thank you. Thank you very much. At this point, I'd like to go into the public communication. So any member of the public like to say anything at this point? We have approximately 3 minutes. Javi, did you raise your hand? Oh, no. I thought you did. All right. So at this point, I will go ahead and now declare the public communication closed. At this point, we're going to go on item 1, which is a hearing before the City Council pursuant to Baldwin Park Municipal Code Section 100.260E, appealing the Chief Executive Officer's cancellation of Hadley's toll franchise toll agreement. So just to let everyone know, there was an actual hearing that took place, and of course with the CEO and the actual and that was the recommendation of the cancellation of the Hadley tolls franchise toll agreement. So at this point, this is an appeals process. But City Attorney, yes, sir.
Yes, Mr. Mayor, thank you very much. I'd like to just give a brief overview
Sure.
of what the procedure that we're going to go over. Also to let you know that the CEO, Shannon Yahtzee, did make a determination, and he didn't make any recommendation to this body. He made his own determination that the franchise agreement should be canceled. And so now that determination has been appealed to this body, and you will make your own independent determination of what you believe based on the evidence that's presented today and anything else that you have looked at. I did speak with Mr. Evans, who's representing Hadley Tow here today, and asked him if it would be okay if we did the procedure so that the city staff could present their portion of the hearing. That way they would have the advantage of hearing the city staff and being able to rebut whatever they say. So I thought that would be appropriate. Mr. Evans agreed. Is that true?
That's correct.
And so without further ado, but I do say that what we'll have is that staff come in. They'll be asked questions for the council to listen to based on their conclusions in the case. Then Mr. Evans and Mr. Hassan will be able to present their portion of the case. And then after that, the council can deliberate or do whatever they wish, and then the council will need to make a decision today about whether to revoke, cancel, or suspend the franchise agreement, or whether to do nothing.
All right. Okay, so at this point, we'll go ahead and open it up. So I'm going to go ahead and, do you want staff first?
I think it would be best, and Mr. Evans suggested that he was in agreement. So,
Okay, that's fine.
if we could, would you mind if we brought them in over here so you don't have to move? Is that okay? So if you want to...
No, I'm quite comfortable right here.
Okay, fair enough. All right, so is it Ron that we'll have first regarding Exhibit A?
I
think it was Ron. Or Sam?
Sam and police department is here, depending on your question.
Police is for number 3, but I think Sam, if you come for a moment, I'll ask some questions here. Okay.
All right, who's that? Go ahead.
And
Yeah.
This is just an informal hearing. Nobody's under oath. Nobody's under penalty of perjury. The rules of evidence have been relaxed. There's no rules of evidence. Anybody can present anything they want. You can talk about hearsay. You can talk about anything you wish. Okay? It's the city's position that the CUP, PC 1618, CP-836, has various terms that include A, developing the property according to Exhibit A, B, B, provide a video camera surveillance system, C, a video camera approval by the Baldwin Park Police Department, D, provide rooftop numbering on all structures, E, provide all landscaping within the site, F, comply with the MPDES requirements, G, submit a lighting plan, J, submit an SUSMP plan, K, submit a grading plan, R, plant 5 trees on Westcott, S, install 2 streetlights on Westcott, T, remove any unused driveways and replace them with full-height gutter, curb, gutter, and sidewalk. I will tell you that it is, and I'll let him, Mr. Evans, make his presentation, but I'll let you know as a matter of context that Mr. Hassan and his lawyer claim that J, R, S, and T are not part of the original SUP.
Legal counsel, so you hold on. J,
R, S, and T are not part of the original conditional use permit. I believe their theory is that because it's not contained in the staff report, but I'll let them tell you about that. Okay? All right.
Can I make one objection, if I could? You're referring to 12819 Garvey Avenue?
I am referring to 12819 Garvey Avenue.
So you know our position is that the franchise and our operations are not at that location, and that we are operating out of the location to the left, 12793, and the franchise itself exclusively refers to 12793.
I understand.
hold on real quick. Legal counsel, we're talking about, because there's 2 conditional use permits, right? We're talking a specific one here, or which one?
Yes, both conditional use permits are part of this hearing. He is correct that the other lot is the one that they're using for the tow franchise. But both CUPs are part of the hearing, so we have to go over both CUPs.
Okay, right.
Robert, can I ask you, what you're referring to right now is actually the CUP, or the conditions of approval. Do we have copies of that, or are they in this document here?
Yes, you do. Hold on just a moment.
Just so that we can
So
follow.
if you may go, there's an index there of all of the different documents, and one of them is the CUP, so you can follow along there.
Resolution PC 1618.
And I also provided copies to Mr. Evans, and I also am going to provide copies to our senior.
It should be exhibit number 2. Or, I'm sorry, exhibit number 3.
Yeah, here it is, right here.
Exhibit number 3, PC 1618.
This was sent to me.
12819 Garvey.
So this one's in here as well,
Okay,
right?
so, yes, no, this is a different document. So here's the,
That's what I just said.
okay, so if you could turn to tab number 3, and if you notice, there's blank pages in front of them that say tab. So if you see this tab number 3, that's what I want you to come to. When you get there, I would like you to turn to page 3 of tab number 3. It starts at the top of section 3.
Okay, hold on. I don't think I have the same paper.
You're looking at my set of exhibits.
Looks like this.
I'm sorry.
It's this
Not
one.
this?
This one, that's his. I'm going to go over the city documents right now. And these will be tab 3. And I'm going to be going right here, starting with A. Okay? So this is the actual CUP, CP 836, PC 16-18. Great, thank you so very much. So this is the actual CUP. You see A, Property shall be developed and maintained in substantial accordance with Exhibit A. B, shall be operated as subject property maintained in a neat and orderly manner. C, provide a video camera surveillance system. D, provide rooftop numbering. And also in C, they have to propose the surveillance system and placement shall be submitted to the police department for review and approval. E, any and all landscape areas within the site shall be automatically irrigated and maintained. F, shall comply with the National Pollution Discharge Elimination System. G, prohibited from using this to deposit or expose hazardous materials. That's not a part of this hearing. H, suitable lighting shall be provided to adequately illuminate the vehicular storage areas. That is not a part of this hearing. I, any proposed structure shall be developed in compliance with the current development standards. That is not part of this hearing. J, provide an SUSMP submittal. That is part of this hearing. That's what we have in the documents here. K, that's also part of our hearing. Submit the grading plan. L, no. M, no. N, no. O, no. P, Q, no. R, plant 5 street trees. That's part of the hearing today, whether or not that was done. S, install 2 street lights. That is part of our hearing today. And T, remove any unused driveway and replace with full height curb, gutter, and sidewalk. Okay?
Mr. Tafoya, I have to inquire, because when I agreed to let you go forward, I thought there was going to be some brief presentation leading up to my opportunity to appeal. You're spending quite a bit of time going over a CUP that is not the property that we proposed, not the property that we're operating, and we're going to be going over a lot of detail that has nothing whatsoever to do with the operation of the franchise.
Robert, can I speak to that just from a legislator's point of view? When we first adopted the second CUP, and I had many conversations with Mark Hassan, good person, complete businessman, also accompanied by Richard Alatorre, same sentiment. What we did was we changed the zoning at that site so that it could be improved, so that it could contribute to the community versus being blighted.
Right.
So this is very much part of the conversation that we want to have tonight, because this was a CUP that we issued, that we approved, and we provided conditions of approval. And so it's important that we go through each one of them to understand which conditions have been met and which have not, because it is absolutely part of the dialogue today.
Okay, I need to respond, because we have a contract with the city that specifically refers to 12793, and that's the location that we are operating out of. That is the location we have a city business license. We are not operating out of 12819. We were hoping in the future to be able to move the location from 12793 to 12819, but we haven't done that. So you understand, this is an action to cancel our franchise because, as alleged by the city, we don't have a legitimate or valid business license at 12793. The issue about 12819 came up when the city, when it initially started the process on January 8th, said, you don't have a valid CUP for 12819. And we said, we're not operating at 12819. We hope to in the future, but we can't because we don't have a valid CUP. We are operating and only operating with a city business license at 12793. So you can smear us all you want about 12819, but we're not operating there. It's not part of our franchise. If you terminate us because of what we haven't done at 12819, that is extraordinarily premature and unfair, because we are not operating there. We have never agreed to operate there. We never proposed to operate there. Yes, we do want to make that property useful. We do want to use it in the future. But wanting to do something in the future is not a basis to cancel or terminate our franchise.
Well, I think we'll get into that CUP next. We're going to go through this one first, and I will disagree with you respectfully, Mr. Evans. In my initial conversations, and I was a very strong advocate for this business and the CUP of this business. What was communicated to me was that the operations at the old site would be transferred over to the new site. So that was communicated to me, but we're going to get there. So let's continue with this, please.
Yes, thank you very much, Vice Mayor Garcia. Also, I would also add that it is properly part of this hearing because we sent you a letter and told you everything that this hearing is going to be about. And so everything that's in the letter we sent to you is properly part of the hearing. And I do agree with you that the other CUP is important as well, and we will get there. Okay, and I'm sorry, I'll be as quick as I can. Okay. The only reason I wanted to go over this CUP is because I wanted to show the council, or to show whoever's here, what the CUP actually says. And again, I've indicated that Mr. Hassan's position is that J, R, S, and T are not part of the original SCUP. Okay? That's why I thought it was important to look at. Okay.
So, legal counsel, so they're indicating that J, R, S, and T are not a part.
That's what they claim.
All right.
Yes.
But in essence, according to the CUP, it is part of it.
The CUP has it in there. I believe Mr. Hassan and his lawyer will state that it's not part of the CUP because it was not in the staff report. And they are correct. It was not in the staff report. The staff report is in error. But a staff report is not a legal document. The CUP is a legal document. And that's why I wanted you to see the CUP.
Okay.
Okay, so starting with A, the city's contention is that Hassan has failed, Mr. Hassan and Hadley Toe has failed to develop the property according to Exhibit A in the CUP. Mr. Gutierrez, have you or anyone in your department done an investigation to determine or conclude whether or not the property at 12819 is in accordance with Exhibit A of the CUP? It's yes or no. Anybody feel free? Yes. Okay. Came to any conclusions about whether the property is in accordance with Exhibit A pursuant to the CUP?
Pursuant to the CUP and those items related directly to the engineering conditions, not been specifically.
Oh, okay, hold on. And then, so I'm going to go through each one with you, and I want to do that in a very chronological way, so that everybody knows exactly where we're moving.
I have to state an objection for the record.
Okay.
We conducted a hearing on January 29th, and whatever evidence the city had or didn't have was presented at that time. We presented whatever evidence we had. What we're doing now is creating a completely new record. So this is no longer an appeal. It's now a new evidentiary hearing with new evidence, and I don't think that's the proper procedure, and I object to the introduction of new evidence when none of that evidence was submitted at the time of the prior hearing.
Okay, I disagree. That hearing was in order to show cause for you to submit evidence. The city had all of this evidence and was able to speak with Mr. Gutierrez before that hearing. I want to give you the benefit of this additional evidence so that you can have it available to you here today. I hear your objection, and it's noted. So can we move forward?
I will make just a response. I don't think that's fair in the context of an appeal. The record that we are appealing and the action we are appealing was based upon the evidence that was submitted at the time of the hearing. To conduct a new evidentiary hearing and introduce new evidence that we've never seen before is unfair, and it's a surprise, and it violates our due process rights.
Real quick, legal counsel, everything was provided to the legal counsel that's represented.
This testimony was never
Everything was provided in the letter, exactly what we're going over today. So he's going to make his objections, let him make them, and then we'll move on.
Okay. Right.
This is an informal hearing. None of these objections matter anyway. There's no rules of evidence. Everything he's talking about are rules of evidence that don't apply to you.
Okay.
So just let him make his objections, and then we'll just move
Okay,
on.
all right. So at this point, hold on real quick. So at this point, make it clear. So they basically have all the material that the legal counsel would represent Mr. Hadley, where they were provided with everything.
That's correct.
That's absolutely a false statement. I was given a letter telling us the proposed action of the city. We have never heard from this witness or any other witnesses, and I've been completely sandbagged tonight. When Mr. Tafoya said, "Do you mind if we just do a little presentation by the staff?" I had no information that he was going to be introducing testimony or new evidence that we've never seen before. A letter which set forth the city's position is one thing. having live testimony of witnesses we have never seen before is completely inappropriate and a violation of our due process rights. This evidence should have been submitted to us in advance. We should have gotten some advance notice that there would be witnesses that had not been presented previously, and we're being denied our due process rights. This is not appropriate at an appeal hearing. The evidence and the record has already been established.
And Mayor, if
Yes,
I may,
Vice Mayor.
in this forum, this is what we're used to doing. So, like when a staff report is brought to the city council and it pertains to a certain area of the city, we will usually ask the director of that department to inform us. And so that's what I think is happening here. So, if legal counsel has sent a letter and that this information has been provided to you, Sam, being our Director of Public Works, is now really chiming in for the City Council's purposes here.
This is not a public hearing. I understand what you're saying. At a public hearing where there's an agendized item, new information can be added, people can be called to testify or speak. This is an appeal hearing. We're appealing a ruling that was made previously. This is not the opportunity for the city to add new evidence and new facts that were never presented to us before. This is totally inappropriate for an appeal hearing. It would be completely appropriate for a public hearing where everyone has a chance to submit information at the same time. But we're being presented with information we never had before this hearing and have never had an opportunity to respond to it or evaluate it before this hearing. So this is not an appeal. It's an evidentiary hearing which should have occurred at the first level before the CEO. It did not occur. And this is not an appropriate appeal hearing.
It did occur. It is an appropriate hearing. Again, the objections can be made, and they can raise those objections with the court at a later time.
So you're saying this witness came and testified at the prior hearing?
Sir, if you would allow me to finish.
You just said this happened before.
Okay, hold on real quick. Let the legal counsel, and then after you have your opportunity. Okay, thank you.
I'm telling you that the information that's being provided at this hearing is the same information that was provided to you at the last hearing. You knew the staff had gone out. You knew they had made conclusions. You knew what their conclusions were. We told you what they were. It's just you didn't hear from the actual man. But we gave all of this information to you before. So just make objections.
None of this information was provided before.
Okay, I disagree.
Not a single aspect of what you've been presenting to this witness was ever disclosed to us before.
I disagree. We told you that there was an investigation into A, and we determined that that was not.
None of that information was provided to us.
Well, why does the letter says it? That you're in violation. But anyway, let's
It's a conclusion. It's not evidence.
Okay. Whatever you say, just make it for the record and then allow me to finish. Could we do it?
And you told me in advance that you were going to do evidence as opposed to just making a general
Make your
presentation.
objection, sir, and allow me to finish.
I've made my objection. This is a ridiculous use of an appeal.
Fair enough.
All
May I
right.
finish?
So at this point, let's go ahead and move on.
Okay.
All right, thank you.
Would you like to go first? Give me that option.
Well, can you tell me how many witnesses you're going to call?
Just A, B, C, D, E, just the ones right down here. The same stuff we told you before.
No, what witnesses are you going to call?
Mr. Gutierrez that looked at all of these issues, the police officer that you say approved your security plan, and that's it.
And Ron Garcia.
Oh, and Ron Garcia.
This is not a fair appeal. You're introducing live witnesses that we've never had a chance to examine or talk to. It's not a fair appeal.
Please make your objections, and may we continue.
I'm objecting. You're asking my permission? No, this is not a fair appeal. These people should have been presented to us. We should have had a chance to talk to them in advance of this hearing.
All of this information was presented to you.
None
You
of
had
it.
every opportunity to talk with them if you wished, and you chose not to do so.
We had no opportunity to talk to them. All we received is a letter dated January 8th and a letter dated January 17th.
Hold on, Shannon. Go ahead.
Can I just?
These gentlemen sat through the hearing with you
I
and
I
answered
right there with
questions.
you.
I sat through
Yeah, they
both
were.
hearing sessions, and I can tell you that I specifically even spoke to your engineer about precisely about these
At the
items.
hearing,
Not at the hearing I was at. You didn't
Yes.
talk to anyone.
yes.
Mark?
And was I given the opportunity to talk to him during the hearing?
Yes, you were.
No, I was not.
Okay, you know, at this point, you know what, I don't want to be here all night. Let's just get with the case, and of course, this is an appeal with reference to what the CEO had suggested. So let's move on at this point. Okay? All right.
Did you or anyone at your office look into the camera surveillance system in your department?
not in the Public Works Department, but I referred it to.
Okay.
Someone applying to volunteer.
All right, Mr. Garcia, did you or anyone in your department review the video surveillance system?
No, that is the purview of the police department.
Okay. Lieutenant Hoffert, did anybody ever get a video camera surveillance system approved at this location, approved by the Baldwin Park Police Department?
Which of the two locations?
This would be 12793 and 12819.
The first one, yes, the second one.
12793. So 12793 was the surveillance system was approved by the Baldwin Park Police Department. Second one, no. Is that correct?
Yes.
Thank you. And I'll ask these questions to both Sam and Ron, since whoever is the one that has the right information can answer. There's no other questions for Lieutenant Hoffert. At this location, was there any rooftop numbering on all structures? Have you done an inspection of the property?
On review of the case file, there was no evidence that the numbering was
Okay. Was there any landscaping on the property with automatic irrigation?
Objection vague as to time, what time frame?
Go ahead, you can answer.
So there is some landscaping that was installed on private property facing Garvey Avenue, adjacent to the site.
Okay. And so are any and all landscaped areas within the two sites, within the one site, automatically irrigated and maintained? Yes or no? All landscaped areas.
So as far as all landscaped areas, there was no evidence found that there was any final driven for approval for any landscaping that was installed to confirm that it was irrigated.
That wasn't his question.
Did you have any evidence at all to suggest that there is landscaping in all of the areas that are automatically irrigated and maintained? Any evidence of that? Has the applicant complied with the NPDES requirements, which is the National Pollution Discharge Elimination System, item F?
Yeah.
They have not. Have they submitted anything in relation to that?
No, I have not, the department has not received any information.
What about a lighting plan? Has the applicant, the appellant, submitted any lighting plan for this project?
The applicant has not submitted a lighting plan.
What about J? Have they submitted an SUSMP plan?
No.
Okay. Have they submitted a grading plan?
There was a submittal, and Ron can speak to that, but there was a submittal in October of 2017, and at this point, I'm not sure if it includes the grading plan.
Ron, do you have any information about whether or not they have submitted a grading plan, SWPP, erosion control plan, and a low impact development standards for stormwater pollution protection? R. Have they planted 5 street trees on Westcott Avenue and 3 trees on Garvey Avenue per the city tree master plan, irrigate 3 wells, and maintain the improvements at that location?
No, they have not planted any trees on Westcott, and trees were planted on Garvey, on private property.
Does it, the 3 that were planted on private property, does that meet the city tree master plan?
No, they are on private property, so they do not, they're not required to meet city standards and so
And does this, okay, fair enough. R. Excuse me. S. Have they installed 2 street lights on West Top Avenue per city street lighting master plan? No, they haven't. T. Have they removed all unused driveways and replaced them with full-height curb, gutter, and sidewalk? No, they haven't. Okay. Do you know of any extension that Hadley Tow has received to complete the conditions of their approval after August 27, 2017? Are you aware of any extension after August 27, 2017, where Hadley has requested additional time to meet their conditions of approval?
No, I'm not aware of any extensions for all that.
Sam, are you aware of any?
I am not aware of any.
All right. Let me move on to CUP Resolution PC 301 dated January 22, 2023 for 12793 Garvey Avenue.
Is that under
Tab number
4?
5.
Tab number 5, please. Thank you. Okay, tab number 5. Okay. Is that tab 5?
Yes. PCO 301.
Oh, yeah, okay.
Now, which property is it? I know it's 12793. Is it the larger property or the smaller?
793.
I think it's a smaller
I don't know
one.
the size.
I think it's a smaller one.
Do we have the map of the
Okay,
parcel?
we'll
here?
send that So the first one we discussed is on the right, and then now we're discussing PCO 301, which is the property on the left.
Now, does that include the vacant property in front of it, or are those two separate?
Two separate. The vacant property was demoed after the expansion of the 10 freeway.
Oh. All right.
This one. All right, let's go. No.
Now, this is the 12793 Garvey Avenue. This was issued a CUP on January 22, 2003 for an auto body shop and an auto storage facility. It has never received a CUP for towing services. So this property cannot be used for towing services with this CUP that it got. This CUP was issued on January 22, 2003. In tab 5, you will see section U on page 3 of PC 301-01. And it says that the use shall be permanently removed for the subject property within a period of 5 years following the date of approval of this resolution, except that prior to the expiration of this time frame, the applicant may request from a planning commission an extension of the provisions of this conditional use permit. So this conditional use permit, unlike the previous one we looked at, is limited to only 5 years by section U. The other one we looked at was unlimited, had no time limit. This one expressly says 5 years only, unless you apply to the planning commission for an extension.
Was there ever an extension filed?
No.
Okay. All right.
There's never been any extension requested or any extension granted by the planning commission regarding this CUP. And the city's position is a very simple one as it relates to this CUP. It expired on its own terms within 5 years, and it was never extended by Hadley Tow. So, those are the two CUPs. Those are the two terms that, those are the two CUPs, and those are the terms that we went over. For the first CUP, A through T. For the second CUP, it's just a matter of, in the city's position, did they get an extension or not? It's only supposed to last 5 years. If they got an extension, then it's good. If they didn't get an extension, then it's not good. And that's for you to determine today. And it's also for you to determine whether or not they have met the conditions of their CUP, A, B, C, D, E, F, G, J, K, R, S, T. Okay, that's the city's position. Again, I think all this information has been provided previously, but I wanted to go over it for the council because you've never heard this before.
I also have a question. So the CUP at the location 12819, I think it was, that was for towing, but this one 12793, this was not for towing. Is that correct?
That's right, 12793
Auto body.
was for auto body and storage. That's the one you gave them a long time
Right,
ago.
2003.
They never had a CUP to do towing. That's why they
Right.
came and got one in 2016.
Mhm.
So this one, 12793 Garvey, the old property,
Mhm.
they got a CUP for this. It's supposed to last 5 years. Storage and towing, storage and auto body. That's it.
Storage and
Not
auto
for
body, and
towing.
then the 12819 did allow for towing.
That is correct.
Okay. So that is,
And if I could clarify, the 12793 was originally given a CUP for budget towing in 2001 with the same 5-year expiration date. And then that was renewed in 2003, but when it was renewed, it was only renewed for existing auto body and auto storage. And the term automobile towing was removed.
Is that for a different company?
Project towing.
Yes.
So that hasn't really
That was Leo.
The
No,
2001 was for Leo Gonzalez owner budget towing, and the 2003 was also in the same applicant, Leo and Erwin Gonzalez.
Okay, so that's the city's position, and what we're claiming, contained in the letters that have been sent to Hadley and discussed in the previous hearings. Now, this is an opportunity for Hadley Tow to show you why none of that is true, and that they have met all the conditions of their CUP.
That's not an accurate statement. What I'm
Or,
doing is-
excuse me,
Hold on.
or some other reason why they should not be canceled, revoked, or suspended. This is their time to present whatever they want to you, for you to make a decision about whether or not their towing franchise should be canceled, revoked, or suspended.
All right, so at this point, we'll go ahead and give it over to Alex Stone.
I'm sorry. The reason why I had to object is because we did have a hearing on January 29th. And we presented substantial evidence at that time. The city did not present any evidence to us whatsoever. We were aware of their allegations relative to the conditional use permits, and we responded to them. But in terms of what evidence they had relative to supporting their position was never presented to us at the prior hearing. That's why I felt I had to object. I'm not trying to offend anyone or bully anyone. It's just we never heard it before. And this is, in the world of appeals, generally you're limited to, you're appealing a decision that was made based upon a certain level of evidence. And none of this was presented to us, and it was somewhat self-serving. But let me give you a little bit of history and a roadmap to why we think.
You said there was a hearing on January 29th. Was that a commission hearing or was that a city council hearing?
That was with.
I'll be happy to respond. It was in the nature of a response to a letter that I attached. I have a Exhibit 2 in my set. I don't know if you have them. They're orange tabs.
Yeah.
Exhibit 2 is the letter dated January 17, 2019, in which it does lay out the position of the city that we're in violation of the conditional use permits. And I will get to that in a moment. But what happened at that hearing was we responded to this letter. So we presented evidence, we presented documents, and we asked the city, I'll go through the whole similar set of facts, but we asked the city, listen, you issued a franchise to us on July 18, 2018, or you approved it through the city council. You issued a contract to us on August 18, 2018. For whatever reason, we didn't start towing under this new contract until somewhere around the second or third week of October 2018. Whatever the conditions of this conditional use permit were for 12793, they had actually existed for somewhere around 16 years. So, or maybe 15 years, depending on how you do the math. So when you issued our franchise, the things that, particularly as to 12793, the things that you're complaining about already existed. And if you look in the staff report, and we'll go through them briefly, the staff report for July 18, 2018, which was dealing with the issuance of two new franchises, ultimately, Royal Coach and our company. The staff report says that our property is a little further away from the police department, but still within the city of Baldwin Park. And it has been approved by the California Highway Patrol. It has been approved by other governmental private agencies. And we are qualified. It's very important to consider this point. In the staff report, and I have it as an attachment, it's Exhibit 3 to my, in the staff report, and I'll refer you to this specific page. Actually, it's Exhibit 4, excuse me. Exhibit 3 was the agenda. In Exhibit 4 is the staff report in which we were dealing with our request to become basically a joint tower with Royal Coach. On page 2 of that document, the second full paragraph, it says that our yard and Royal Coach's yards are acceptable. We're qualified to do the work. At the time of July 18th, 2018, we had been issued city licenses, business licenses, every year from 2003 to 2005. And one of my exhibits is Exhibit 8. Exhibit 8 is a separate exhibit. It's not on the orange tab, but it's loose. Hopefully you can find it. It's the one that has the picture of the business license. Okay. So Exhibit 8 was a compendium of our business licenses, which have been issued since 2005. And you look carefully on the city business license, they all say tow truck. They don't say auto body, auto storage, they say tow truck. And if you look at the first one, I don't know how, well, if you go backwards in time, you have 2007, 2008, 2009. For the last 13 years, Hadley Towing has been issued a business license to do towing at this very location. Now you ask, well, how could that be if it had a conditional use permit that expired? Well, in the scheme of planning, apparently if the city is okay with the use of the property, it will issue a business license, even if there is maybe a small technicality or a big technicality with regard to the status of a conditional use permit. So I wanted to refer you back to the conditional use permit, which is my Exhibit 9. Again, I'm talking about 12793, and there's a very specific reason why I'm talking about 12793. We'll get to the franchise agreement that was issued to Hadley Tow and executed by the city on August 18 of last year, only refers to 12793. It refers to, I think it's page 9 of the agreement, which is my Exhibit 7. Page 9 expressly says that the location for our performance is 12793. So if we look at the Exhibit 9 is the conditional use permit, and if you look at page 3, subparagraph U, it does say what Mr. Tafoya would make reference to, that the use shall be permanently removed within the period of 5 years following the date of approval. So that would be 5 years from 2003, that'd be 2008. And it will be, the Planning Commission will grant an extension, as it says. It uses the word shall. That means that the Planning Commission doesn't have discretion to deny it, provided the use is being operated in violation of the conditions of approval, or the use is adversely affecting properties in the immediate vicinity. As of the time that we got notice on January 8th, and then the second notice January 17th, no one had complained about our use of the property. I would propose that under the circumstances, if you look at that property and its use, no one had complained that our use of that property was adversely affecting their property. And I have not heard in the testimony, other than this gotcha rule, that, well, technically, even though we've given you a city business license for 15 consecutive years, technically you're out of alignment with your CUP. Other than that, I have not heard any evidence that our use of the property is in violation of the conditions of approval of this CUP. And certainly, until this issue came up about our franchise and the competing position with Royal Coach, was obviously the favored tow company in the city for many years, we're just doing our job, towing cars for the CHP, towing cars for the AAA, doing $100,000 a month of business at this 12793 and contributing to the locale for taxes and employment. We're contributing to the city. And we've been doing that for 15 years. And because we went up against the incumbent and were somehow able to convince the city council in July 18, 2018, that two tow companies should be allowed, now we're all of a sudden under this horrible company that is violating the zoning. I would propose to you that under the circumstances of our being granted the franchise, that the condition of our property in terms of its zoning has been the same for 15 consecutive years without interruption, that to suddenly say, aha, we got you, we now know how we can get rid of you so we can give a full contract to Royal Coach, you got a problem with your CUP. And so at the hearing, Mr. Pacheco, you asked about the hearing on January 29th. At the hearing on January 29th, one of the things that we proposed, and we were hoping that there would be some interest, but apparently not, was to allow us to do something pragmatic for the benefit of the community. What we proposed at that hearing was we'll continue to operate at 12793 until we were able to resolve the issues at 12819 in terms of the conditional use permit. We proposed at the January 29th hearing that it would take us approximately 60, perhaps 90 days to complete and resolve any issues relative to the CUP, because the issues that were remaining in the CUP were not overwhelming or difficult. I lost the screen. Was that intended?
Can somebody put the screen on?
And that we could resolve those issues within 90 days. It was, and still is, our intention to ultimately relocate to 12819, because we own that property. At 12793, we are a tenant, and we're paying rent to a landlord that we've had. I guess there was a recent transfer of the property, but we've had a landlord at that property since 2003. So I wanted to go back for a moment to what I was referring to earlier, the staff report from July 18, 2018 on page 2. The staff report unequivocally says that we're in compliance sufficient to award us the franchise, that we have a location that's been accepted by governmental agencies, and there is nothing mentioned about an issue about our CUP. Because the tenant, is it Hofford? I'm glad I got that right. Were you the one that went out to inspect the 12793 prior to the staff report to determine that it was an acceptable property?
No.
You know who did?
Yes.
Who was that?
Officer Esponto.
I'm sorry?
Officer Esponto.
Okay. And did you ever discuss with him that he observed it and it was a good facility for purposes of the tow yard?
His goal is not to assess the overall condition of the property. His goal is to look for cameras.
I was looking for what?
To look for cameras, and he limited his inspection to that.
We're talking about the inspection before the staff report? And what did he determine at 12793?
If there were acceptable cameras.
The what?
There were
There
acceptable
were
cameras.
acceptable cameras.
So he didn't look at anything else?
He may have, but that wasn't the scope of his inspection.
Okay, do you know of, well, let me ask Mr. Gutierrez. Prior to the staff report on July 18, 2018, I'm sorry, these are all new names to me.
Oh, no, I'm not.
Was there an inspection of Hadley Toast property at 12793?
Yes, there was an inspection by the CHP and a report was given to me by the CHP, which I included a copy.
Okay. So at the time of July 18, 2018, are you the head of planning?
Yep.
What is your position?
I am the Public Works Director.
Public Works Director. So were you one of the people that signed off on this property on July for the staff report
Yeah, I wrote the staff report.
for July 18, 2018?
That's correct.
And as of July 18, 2018, as the Public Works Director, I can see your name there, the property was okay for purposes of the franchise.
Yes, as part of the research, I verified that there was a city license that was current, and I received buy-off from the police department for the cameras, and I obtained the CHP report.
Just generally, what did the CHP report say regarding the property?
That the property is certified to tow, I believe, Class A, which is a smaller class.
And that was important for you to know that there was a governmental agency that had inspected and approved the property for towing.
That's correct.
Okay.
I do want to note for the record that I did not research I just looked at the current business license and these other items.
Did you determine that there had been a business license for towing at that location?
That's correct.
And who's responsible for issuing a business license for towing in the city of Baldwin Park?
Well, I'll refer to the planning department or building department, but the business license issues by it's finance, right? But they verify, they won't issue it without confirmation from the planning department.
Okay, so you don't dispute that for 12793, business licenses have been issued for many years,
I do not dispute.
and that's for towing.
That's correct.
Okay.
That was my impression at the time.
And that as of today, there is still a valid business license at that location for towing, correct?
I am not sure. I
Well,
can't
have
say
you
as of today.
have you
As of-
seen anything that indicates that the business license, and it's one of the business licenses, the top business license that's good through May 31, 2019. Do you know what the status of that license is?
I do not know what the status of it is today.
As far as you know, it's still in effect,
Correct.
and that's for towing. So I wanted to go back to my exhibits. I think I don't need to beat a dead horse. On July 18, 2018, the City Council voted, and some of you were present. City Council voted the option of allowing 2 tow companies to operate and issued the approval for 2 franchises. Prior to that time, at meetings that were held within, I guess, May or June, there was a proposed, first there was a proposal to amend the ordinance to allow for a 10-year contract. Then there was I think a city council meeting that was proposing to extend on an exclusive basis Royal Coach's contract for 10 years. At one of these meetings, I think I stood in front of the city council and I said, you know, competition's a really good thing. And allowing a second towing company, even though you may be happy with one, allowing a second towing company is in the public's best interest. Although I would acknowledge, Mr. Chapoy says, well, you can't prove what the intention of the city council was when they voted to allow 2 contracts. I mean, I can't prove it, but common sense is that a decision was made to allow 2 towing companies where there was one before. And it's reasonable to conclude that as of the composition of the city council on July 18, 2018, there was a majority vote to allow 2 towing companies. And again, the reason I bring that up is not to suggest anything other than, as of July 18, 2018, what were the state of affairs, what were the state of facts. And 12793 had a valid business license, its property had been inspected, and I haven't heard any adjoining property owners complaining about the use affecting their properties. So as a practical matter, the issuance of a business license for towing was consistent with a 15-year history, and it wasn't an offense to a CUP that had been issued originally for auto body and auto storage, because when you consider what the use of an auto body and auto storage is, that use is actually a more extensive use in some ways than a towing yard, which is a more passive use of vehicles. An auto body shop is going to be doing a lot of work, a lot of banging, a lot of painting, and the auto storage part of it, in order to get cars into that lot, you're going to have to use tow trucks for the most part, particularly if they've been in accidents. So when you look at that CUP, it's not inconsistent with common sense that towing would be actually a lesser use, a less impactful use than an auto body shop. Excuse me. Now, since, for whatever the reasons were, and I think common sense tells us why, the City Council determined in July of 2018 that 2 towing companies should be permitted, we should look at what events have occurred since July 18, 2018 and now that would warrant a change in that decision. We are aware, and I attached as Exhibit 6, if you could look in my orange tabs, we are now aware. We were not aware on January 16, 2019. We are now aware that there was an agendized item to give Royal Coaches a 10-year extension, the very extension that we spoke vehemently about and against in 2018. And the proposed action in the staff report and in the agenda was to grant a 10-year extension, I guess, which would be in addition to the year that they've had already, grant a 10-year extension, and it was proposed to be exclusive. And we know that because we didn't know that until a few days ago when we saw this. We weren't told about this hearing. It was not disclosed to us, for example, on January 29th. It was not disclosed to us on January 8th when we got the first letter. It was not disclosed to us on January 17th when we got the second letter. And we can't say it's secret because we could have looked at the agenda if we looked every city council meeting to see it was on the agenda. But the city council was requested to approve an extension for 10 years on an exclusive basis. I don't know why it was requested on an exclusive basis, but that would have definitely been a violation of our contract, which still existed at that time. And in order for us to determine what actually happened at that meeting, because there's no minutes available online, we had to listen to the audio recording of that meeting, which we did today for the first time. And we heard Councilmember Avila object to the 10-year extension. And there was already apparently an amendment to a proposed motion to make it non-exclusive, which was a good save because that would have been a direct violation of our contract. But if you look at page 2 of this document, actually starting on the bottom of page 1, it says Royal Coaches Yard and Business Office are now located. This is the exact wording, verbatim, from the July 18, 2018 staff report. So essentially the staff report is repeating that both yards have been approved, both towing operators have been accepted or certified, they meet the requirements. Okay. Earlier in this document, it makes reference to enforcement action against Hadley Tow. However, as of January 16, 2019, there was no actual true enforcement action against Hadley Tow. And how do we know that? Go back to my exhibit number 1. We have a letter that's dated January 8 from the city, which was our first notice that something was up with the city. That letter refers to 12819 Darby Avenue. It only refers to 12819. I've already covered sufficiently the fact that our franchise, both our application for the franchise and the actual contract that we signed, makes no reference to 12819. And so we cannot possibly be in violation of our franchise for a property that we don't operate at that was not part of our franchise. So Mr. Hassan and one other person, or maybe two other people, came to the city to discuss this, and they brought to the attention of Mr. Tafoya and Mr. Shannon that, what are you talking about in your letter of January 8th? We're not operating our tow business at 12819. Why are you sending us a letter saying that we're going to lose our franchise regarding a CUP when we're not even operating there? And that's not part of our franchise. So in response to that comment, we get letter number 2, which is exhibit number 2. And it's a letter dated January 17, 2019. And this, for the first time, makes reference to 12793 and an issue regarding our CUP at that point. So here's the predicament that I'm hoping that you're looking at, because most likely the judge is going to be reviewing these facts as well. You took action on January 16, 2019 to effectively nullify our franchise. Although, fortunately, I guess for the city in the way they did it, they didn't make it what was proposed, the exclusive right. But we hadn't even been notified of a legitimate problem with our franchise until the day after you voted to essentially or effectively nullify our franchise by granting the incumbent the 10-year extension that we had been fighting in 2018 and successfully fought off. So January 17, 2019 is the first time that we're getting a bona fide issue that relates to the property that we operate at, 12793. Here's the problem with the proposed action against our franchise. We have a valid city business license. If you look at the letter, Exhibit 2, the premise of the letter says you don't have a valid city business license. But we do. You just had testimony from the Public Works Director that we have a valid business license. To this day, we have a valid business license. One of the points that I brought up on January 29th to Mr. Tafoya and the CEO is, are you taking action against our business license? Because this letter says we don't have a valid business license. We have a valid business license. The city has issued it not only for the current term, but for 14 prior years. Are you taking action against our city business license? The answer is, we're doing what we're doing. We're going to cancel your franchise. We understand the reality of politics that the composition of the City Council on July 18, 2018 is different than the composition today. However, the public interest that existed on July 18, 2018 that warranted the City Council awarding 2 franchises and 2 contracts, nothing has changed. The circumstances have remained the same. One of our concerns is not only that because of a political an election in November, that the public is not benefiting from this sudden change and in fact is being harmed. While the staff makes reference in the original report on July 18, 2018 that it thinks it's difficult to have 2 toll operators, we were operating, fortunately not until October 18th or thereabouts, we were operating for October, November, and December. And I haven't heard a single complaint about what we've done. And initially, our revenue was modest, but by December, our revenue for just the work we were doing for the city of Baldwin Park was approximately $30,000. Okay. And we know that's probably even a little bit low. But what happened is that before any action was formally filed against us, so to speak, on January 8th, the same day as the letter that I referenced, which is Exhibit 1, we were taken off the road. The CEO took us off the road. Now, I can understand if we had a problem with our insurance. I can understand if we had some misconduct involving our operations. But taking us off the road on January 8th, when we've done nothing wrong other than operate consistent with our original franchise, we asked to be put back on the road, and we were told, no, nothing is going to happen in your favor. We are not going to put you back on the road. So I understand that the staff apparently believes it's in the best interest of the city to have one tow operator, but I don't believe the staff has the authority to countermand the authority of the city council and the franchise agreement that we signed with the city to take us off the road simply because they can. One of the concerns we have in this context is my client also has invested hundreds of thousands of dollars as a result of getting this contract. My client also has a property at 12793 that it pays a lot of money in rent, and ultimately, I'll talk about 12819, my client purchased that property, but ultimately, it's not just Royal Coaches that has a stake in the outcome of this proceeding. Yes, as a result of the City Council action on July 18, 2018, starting in October, Royal Coaches' income went down. Approximately, it should go down in half. But that was the will of the City Council. And to take our business interests away simply because you can, because our only recourse is to pursue this administrative process, I think is an injustice. I'm not making a threat, but as a practical matter, the way that this has been handled, including taking contrary action on January 16th based upon alleged enforcement action that had not actually commenced, I think smacks of lack of due process, a violation of our contract. I think that if this appeal is not granted, well, I know if this appeal is not granted, the court is going to be reviewing these facts. And I think the fact that the city has acted arbitrarily in taking this off the road, that the circumstances that existed on July 18 have not changed. The circumstances of our zoning and our business license have not changed from the date that it was submitted and approved by the City Council. So to take us off the road and then conduct a hearing where we've not presented with any evidence whatsoever, we were not given anything other than the letter from the city. We were told to justify or respond to the city's letter. No evidence was provided. And to be told that, well, you don't have a city business license, when we said, no, here it is. Those facts are not the kind of facts that I think any city wants to defend, but obviously it's up to you to make that decision. We have another exhibit. I don't know whose phone that is. We have another exhibit that we marked as Exhibit 10. And it's a color photograph, and it's Royal Coaches Yard. If you don't have a single exhibit, then you don't have it. I thought I gave everyone one of them. That's it, yes. Okay. What I've marked as Exhibit 10 is an aerial photograph of the Royal Coaches facility. We know, because we've spoken to the complaining party, Greg Tuttle, that there has been an ongoing investigation of Royal Coaches Yard and its facilities for at least 6 months. And that there are permanent structures that have been constructed on their property without any city approvals, building permits. There are permanent structures there that exist that are depicted in, I think, one of these circles. Royal Coaches, in the last 20 years, has purchased residences adjacent to its property. And we believe, in good faith, we believe that their properties, including several of their storage yards, and the ones that we've circled, I think, are relevant, circled in red, do not have conditional use permits to allow that type of use. Each of those properties that we've circled in this picture have different assessor parcel numbers. So they're not part of the Royal Coach's original property. And they have been added since the 90s, at least, and maybe more recently. Our concern is that my client is being singled out because of this competition between my client and Royal Coaches, and that because of the change in composition of the City Council, we're in a weaker position we were than as of July 18th, but the public interest is the same. So we are being singled out or addressed on what we consider to be no change of circumstances, but again, a gotcha rule. And what we asked on January 29th is work with us. Give us some time, approximately 90 days, to complete whatever needs to be done on 12819 so we can move to that property. And I'll have Mark briefly go over what needs to be done to get that property ready. But the reason we bring that up is not because we agree with the city that we can lose our franchise and have our franchise canceled, revoked, or suspended because of anything having to do with 12819. Mayor Pro Tem Monica Garcia mentions that she was involved in that property and wanting it to become developed and become useful. One of the issues that we've had with that property is that there was problems with homeless people that resided, unfortunately, or didn't reside. They hung out in that area. And when we had them evicted, they retaliated by causing fires on our property. We've had 2 separate fires. Since 2016, we've had 2 separate fires, and it's materially damaged the property. However, we have spent hundreds of thousands of dollars doing physical improvements, and I'll have Mark explain what he's done, to that property. And what is remaining to be done, primarily, the thing that might take the most time, we need to have somebody do a water study to determine, I think, some kind of grading in that property, which is a legitimate issue, but it's a study. We've done most of the work that needs to be done. Because of the fire, we lost the numbering on the top of the building. Because of the fire, we have to redo the interior of a building structure. But none of that would take more than 60 or 90 days to complete. Why didn't we do it before? Well, to be honest with you, until we got the contract from City of Baldwin Park, we didn't feel that it was economically feasible for us to invest the amount of money necessary at that time. But that's not really a good excuse because we can complete that work and move from 12793 to 12819. And we proposed this to Shannon and Mr. Tafoya, and they asked me, well, put it in writing, what you're prepared to do, and we did. So within a day, approximately 24 hours of January 29th, we said, listen, this is what we can do. We can complete anything that needs to be done and satisfy the city's concerns by May 1st. And that was on January 29th, not that far away. Whether we can still do it in that time frame, I'm not positive. But certainly, it's not the work that needs to be done to complete that project is not that extensive that it can be completed. The only condition that we placed on that time frame was our concern about getting, if we needed to have a approval from a department within the city, and if that took longer than anticipated. But approximately 90 days would be all that would be necessary to get that property ready. In saying that, there is nothing in our franchise that requires us to relocate. There's nothing in our franchise that mentions 12819, and we cannot possibly be in violation of our franchise because we didn't comply with the conditions of a CUP at a property that's not part of our franchise. But Mark, would you briefly explain what you would have to do to get, as far as you can tell in terms of timing, to get that property in compliance?
12819?
Yes.
So, I know Mr. Tafoya mentioned all the things that we did not complete, and Monica, thank you for supporting 12819 and giving us the opportunity to do the CUP. So far, we did the 8-foot block wall, which costed about $60,000. We finished the landscaping. We did the electric gates, and we did the 2 driveway approaches. I don't know if you guys are aware, but when they did the 10 freeway expansion, we lost the sidewalks, we lost the driveway approaches, so all that was redone. So I was able to redo the work that.
Mark, would you go to that and show them?
Anyone have
Like a pointer or
I
something?
can go up there.
Why don't you go up there and briefly
Do
show
you have a
them?
pointer, Sam?
I don't mind if you get up and go there. This is helpful to them.
Okay.
That's fine. And give you a little exercise while you're sitting.
All right, so I wasn't able to do the buildings that caught fire twice on New Year's Eve. One of the reasons was we got the fire report from the fire department. However, we had some challenges with the insurance company. However, I was able to do the driveway approaches. I'll stand up. It's okay. This is the first driveway approach. When they expanded the 10th freeway, they took about 15 to 20 feet from Darby. So all these driveway approaches were dirt. We did the handicap ADA compliance here. The first driveway approach, the second. We did an 8-foot block wall all the way down, which costed about $60,000. We paved this section here underneath the Edison lines. We also installed 2 electric gates on both of the driveways. We did some minor work and some minor repairs inside the buildings. However, we did not complete the buildings due to building permits and some minor changes. Even though I don't have a camera system on this facility, I do have pixel zoom cameras that zoom in over 300 feet that are here on a pole that can zoom in and rotate. I do have an alarm set up from all the access to the homeless people. But all this work was done because I was able to do so with the exception of the fires that happened here.
What
Can I
happens?
ask you,
Yeah.
is that your property next?
No, this is the mobile home park.
Oh,
This is office 1, office 2. We had, obviously, anytime the office here reported there was some homeless people that broke into the facility, the cops would come out and either cite them or take them off the premises. Well, they came in 2 different times. One of the times was on New Year's Eve, and they set the building on fire. Since then, until today, we still haven't been compensated from the insurance company on the fire damage that's been done in these 2 buildings. So my idea was I would continue to operate out of 12793. I prepared the RFP for this franchise. I clearly stated 12793. I never once stated 12819 in my franchise. The signed agreement that I signed with, I believe it was Sam or the other gentleman, they kind of look alike. It was 12793. So I didn't try to pull any fast ones or stand back and see or pull any fast tricks. The franchise was always assigned to 12793. When customers showed up to retrieve their vehicles, they came into this office here. When my employees report to work, they come to this office here. As you can see, there's a tow truck pulling in and out of this driveway. Most of the vehicles here on this facility are my own vehicles. Like we have a bunch of old tow trucks that are retired from 2008 that are here. We have some equipment that doesn't comply with the new emission requirement that can only be sold to Mexico or out of state. That's stored here. However, everything that we operate under this franchise is at 12793. So my ultimate goal, which I've expressed to Shannon over the phone, was we can have all this completed and approved by May 1st. We would then vacate from 12793 and move into this building.
Now, there was a mention about not having the numbers on the top of the buildings. Does that have something to do with what happened to the property?
Correct. This building had a roof numbering, and it was damaged from the fire.
Can I just ask a quick question? Because you keep mentioning the fires. When did the fires occur?
The first one was in either, because it was New Year's Eve. I don't know if it was 14 or 15. The second was a real one.
So that would be 2016?
One was in 2015-16, and one was 2014-15.
So you're telling me you haven't fixed this since over 2 years? 3 years now?
I did the clean out. I did all the demo. I did all the demo work. I cleaned out all the rubbish, and the only thing that's not done is the build out, basically the framing and the gravel.
So, again, my question is, so you haven't resolved, because your attorney stated, please correct me if I'm wrong, your attorney stated you haven't done your work because of the fires And again, the contract wasn't, again, the staff memo reports July of 2018. So your attorney basically stated that you haven't done the work because of the fires related to this. So I'm kind of confused as to why you've waited so long to do the work on your buildings when you didn't really receive, when you didn't have or were aware that you were receiving a contract until July of 2018.
Okay, well, for one, the insurance company still hasn't paid out on this claim. There's an open claim currently on these two buildings. Two, he's referring to two different things. On July 2018, he's referring to the towing franchise. This CUP was approved in 2016. Two different topics. I don't know if I answered the question.
You did. You've answered it.
So, Monica, to answer your concern, a lot of this work costed over $100,000. The only work that's not been done is this work here. On the original resolution that I received, that I reviewed with Amy, which I provided to everyone at the hearing, did not have the last four items in that resolution. The resolution that was provided by Mr. Tafoya and by the city had 4 additional items. When I got the first resolution, I went to City Hall and met with Amy, and I went line item by line item. So the last 4 items on that second resolution weren't in the original resolution. I provided a copy of the original resolution, which has the signature of, I believe, the city clerk or somebody in planning, showing the last 4 items that were included. However, a lot of the work has been done. Compared to what the property looked like this before, and look how it looks now. The property is screened all the way down. Before, there was no wall, there was no fence, it was wide open because of the 10 freeway expansion. Now it has an 8-foot block wall, has gates, and it's all screened. You can't see any of this stuff from the outside.
What time frame would you recommend to the city in terms of getting the rest of the work done so that you could move from 12793 to 12819?
By May 1st.
So by May 1st?
The water quality management plan can be completed from the architect within 30 days. That gets submitted to the city. And since all the water, there's no water runoff, and this property is already paved, it's just basically preparing the plan. It has to get submitted to the city and approved by the city.
What else? Well, the reference to cameras, street lights, other things.
Public Works can approve the 4 trees that go in West Bath, which the contractor at the hearing said that he can have this done within 30 days.
Does
Real
this
quick.
include rebuilding the fire built damage?
By May 1st? Yes. But we also have an office here that we can operate out of, and this would be the toilet.
Okay, hold on. Vice Mayor Monica Garcia.
Yeah, thank you. And no, thank you for pointing out the improvements that you have made, and thank you for those improvements. I think that when the renderings were presented and we had our initial conversations, I think we had a different end point, if you will. But thank you for those improvements. I will say that in July of 2018, when the franchise item was taken up, in that staff report on the second page, in the second paragraph, it did, and this is what caused me concern. So when you say that nothing has changed, you're right. Many things have not changed, including my concerns, which were, when I read this report, it really called something out to me. It said Hadley Tow is only Class A light duty. CHP approved, and only 1 storage facility is approved for 3 area districts. A new facility currently undergoing remodeling was not ready for this year's CHP inspections. Therefore, it's not CHP approved. So this was a concern to me because, first of all, it's talking about compliance issues. When we look back at the original CUP for this site, which is called out in the staff report, the date is passed and approved August 24, 2016. And one of the conditions says, within 6 months after the date of approval of the modification, all conditions of approval have not been satisfied. These listed entitlements shall become null and void. 2016, fast forward to nearly 2 years later, I have to ask the question, why, if now, Mark, you say that those improvements can be done by May, why has it taken more than 2 years to make those improvements? Then you move down to maybe the third paragraph, after options 1, 2, and 3. It does, and this was also new information to me in the staff report. Option 3 is allowed by the BMPC. However, using multiple towing companies could be cumbersome for the police department in dealing with response times and interpretation of franchise agreement when disputes occur. And it goes on to talk about that being, not the preference of the police department. And that was new information for me. Additionally,
When you say new information, you mean new information at the time?
at the time in the staff report. And then additionally, like I mentioned, I was a strong advocate for changing the zoning here because I was under the impression this was what was communicated to me, that these improvements would be made. It would be, contributing to the community in that way. And that the operations would be moved over, because I was told at the time that there were some significant carrying costs at 12819. And because the land use was not consistent in allowing the tow use, that, Mr. Hassan marked that you had these carrying costs, but you could not utilize the property for these purposes. Here we are in March of 2019. And I hear what you're saying, but you have to understand the frustration. And so when we look at the staff report of July 2018, and you say nothing has changed, many things have not changed. You're absolutely right. And that's what brings us here today. By looking at the items that were called out in the staff report, one could argue that the decision made on that day was purely political. Because, when I look at the two, one has full towing abilities, and one has a light duty. And because of the compliance issues, and these have been ongoing. So I just think that, the city has given ample opportunity. I don't know why these improvements have not been made to date. I think that, perhaps if they would have been, we would be having a different conversation. But that's just what I want to point out. When you say nothing has changed, I agree with you on many points. And compliance issues, renovation of the property, the PD's preference, I would imagine. And, when you look at the makeup of the council, there are 2 members here on this council that expressed concerns even on July 2018. There are 2 new council members. And so with that information, I just...
Okay, let me, first of all,
We're not done with our presentation, but okay.
Hold on. Can I say something real quick? Let me circle back here for a second. And trust me, I know it's political. I've watched Baldwin Park since the year 2000, for the last 19 years. So going back to what Shannon mentioned earlier about 12793, first you guys say it wasn't a CUP for towing. Well, budget tow, they're called budget towing. It wasn't budget auto body. Budget towing had the franchise, had the Baldwin Park police contract out of 12793 East Garden prior.
That's it.
So when I applied for this franchise, I did the same. I applied for this franchise for 12793. When I received the letter on January 8th, it only stated 12819. 12819 is not in the franchise. It may be in your CUP or in the vote that you were a part of in 2016, but the vote that you were a part of in 2018 did not include 12819. So for the record, what you mentioned earlier about budget towing and the CUP issued in 2001, Mr. Lozano was around back then, and he assisted Leo, I forgot his name, Gonzalez or Leo Gonzalez. Mr. Lozano assisted Mr. Gonzalez in obtaining that CUP for 12793, and that CUP was valid for 5 years. I don't know how magically in 2003, it was issued in 2001 for 5 years. I don't know how in 2003 it magically switched from a towing and storage to an auto center or auto body. That's what I wanted to bring up as far as that. And when I applied for this franchise, it was only under 12793. It had nothing to do with 12819. The letter that was issued to me on January 8th was pertaining to 12819. They took me off the road on January 8th for 12819, when 12819 wasn't even part of the franchise. In addition to that, the letter on January 17th, when I went back and I explained to Mr. Tafoya and to Shannon over the phone that the franchise was issued to 12793, they circled back and they huddled back in their back room and added to the letter that 12819 and 12793. They added that on January 17th. Well, the night before, you had already voted on giving Royal Coaches a 10-year contract, which you were trying to do last May anyway. So it is political in the city of Baldwin Park.
Hold on.
And don't think I'm going away.
So let me finish our presentation, if I might. And I respect what you said. And it kind of proves the point, Monica, what you just said, and excuse me for using your first name, just easier at this point. What you just said proves the point that I've been making from the beginning of my presentation. City Council took an action on July 18th, rightly or wrongly, and whether, I suspect you voted against that.
I did, yes,
Yeah.
and so did the mayor.
All right. So I understand that, and if you had and you voted today, you would probably have a different vote. But the city did make a legislative action to approve two tow companies. And the problem is that you can't go back and say, you think that was a bad idea. We now have the power to reverse that decision. The problem is that the premise of this action against my client is that it doesn't have a valid business license. That is not a valid point. And if you look at page 7 of Exhibit 5, and it lists the grounds that you can cancel, revoke, or suspend, the reasonable interpretation of this is some action or omission or event that occurs after the contract is signed. If you're already in violation of something, you shouldn't get the contract in the first place. I think that's a reasonable conclusion.
That's my point.
All right. So here, that's my point.
Well, that's my point. That's why I'm saying nothing has changed.
Because my client didn't aggressively pursue 12819, the CUP, that may be disappointing. It may not be good for anyone, but it doesn't give the ground for cancellation, revocation, or suspension. So my point was that on January 8th, the city said, we gotcha. We can get rid of you now because you didn't do what you're supposed to do at 12819. It's not part of the franchise. If you look at paragraph 17 and you go through 1 through 15, it doesn't say if you fail to do something on another property that you're not using that's not part of your franchise, we can revoke, cancel, or suspend your franchise. So it doesn't say another property that we'd like you to use. If you don't use it, you don't aggressively pursue it, and you let it sit, that we can take away your franchise. Now, that's what January 8th, 2019 letter said. The January 17th letter adds 12793, and it's premised on the fact that we don't have a valid business license. We can't have a valid business license when we do. If this was California Coat sitting here, they wouldn't be sitting here. Because it's my client, and politically he's not the favored party, he's now on the defensive over something that no one raised as an issue at the time of July 18th, and no one has raised in 15 years of his use. This is not the kind of record you want to cancel, revoke, or suspend a franchise when the circumstances are that you approved this property, this very specific property, 12793. You signed, someone from the city signed on the dotted line on the contract saying this property is okay to use. And now, just a few months later, you say, aha, we can kick you out, and now we can essentially reverse our decision. Now, if the city council wants to put an agendized item that somehow, some way, it wants to reconsider an action that it took 6 months earlier, then with notice to the public and allow the public to participate in it and have another hearing, and I don't know if that is something that the city can do, that they can just go ahead and reverse an action they took 6 months earlier because of a change in politics. But if you want to do that in an open forum where the public can hear what's going on, go ahead and do it. But to revoke, cancel, or suspend my client's franchise on a false premise that it doesn't have a valid business license because it didn't aggressively pursue an adjoining property which is nowhere part of its franchise, then you have created a situation that hopefully will be reversed by a court, and I'm hoping you do not go there. Let me just go over my notes and make sure that I've covered everything I want to cover.
Mayor, I make some comments.
Yes, please, please.
I'll have a few comments too, Mr. Mayor, very briefly.
Okay, just briefly, I mean, I know you early on object your characterization that somehow this is, you made statements about this being political when you were voted in. You know, I was one of the ones that voted to have 2 contracts. It was not political, it was what I thought was best at that time.
Right.
For the city, okay, so, you know, you make speculations that are not there, that I take issue with.
Well, I didn't say it to
I
offend
think-
anyone, I was.
No, I'm just
trying to-
saying I'm objecting to your characterization. And you're free to have your opinion, but.
Okay.
But that, you know, that's my opinion. You can essentially point out to the business license.
Right.
So you're an attorney, and I'm gonna read the fine print, because I'm sure you have. And it says on there that the person, firm, or corporation named below is granted a certificate purchased to the provisions of the city business tax ordinance to engage in, carry on, or conduct a business, trade, calling, profession, exhibition, occupations, revenue. Insurance of certificate is not an endorsement nor certification of compliance with other ordinances or laws, nor an assurance that the proposed use is in conformance with the city's zoning regulations. This certification is issued without verification that the taxpayer is subject to, example, blah, blah. Okay, so even though every year they approved it, but this doesn't verify that you're in compliance
Well,
with
that's,
ordinance.
I don't dispute that.
They
It's
didn't
just,
go over there and check, right, and go through all the records. I know they issued them a lot of times, and a lot of times businesses are not in compliance with the regulations and ordinance, and they come back later because code enforcement went out there and they'll say just like you, but you gave me a business license, but you know, it doesn't mean
No,
that
but
you're in compliance. So I'm just saying that you're saying, I know they gave you one, but it doesn't necessarily mean
Yeah.
that you're good. Well,
I would say
let me continue on.
as a matter of practice, they don't issue
Hold on,
CUPs.
allow him to
They don't
finish,
issue
please. Legal
business
counsel, legal counsel,
I know, but
please, wait.
Let me just, and on item U, you know, I know it's technical, but it does say that at some point, I don't know, did you guys ever, it says, the applicant may request from planning commission an extension of the provisions of conditional use permit. Now, I don't know if, who was the previous owner? The previous owner was Leo Gonzalez. So did they have it for more than 5 years, and then they didn't come in and get request of planning? Or did you become the owner before the 5 years, or?
I came in 2005.
But not as the owner.
I mean, did you get it after?
When I went to the
Leo, or-
counter to apply for a business license, they told me you have a CUP on file. Otherwise, they wouldn't issue me a business license. Because normally, you would have to go through building and planning, then circle back to business license. If you don't have a CUP on file, they will not issue a business license.
Okay, well, I have to find out how, I don't know, if you should have applied for
I did.
a commission for an extension? You did?
When I went to the counter and I applied, in my application, it said description of the business. I put sewing service and storage. I was told to go check with planning. Planning said you need a CUP. Then planning came back and said you have a CUP on file, go back to business license and pay for your fees. And since then, I've renewed the same business license for 14 years, 13 years. You don't count 2019.
I guess at some point, somebody should have applied for an extension. I mean, I just think it was a missed opportunity.
The extension would have been granted anyway, since there was no change to the property.
But it should have been asked for to confirm it. Okay, I'm just-
We've never got a notice.
Now, when you did apply though, I was under the impression that your franchise was for 1289. I mean, that was like the whole discussion during all these hearings, that it wasn't gonna be here, because I'm not sure that this property at that time was in conformance to what was being requested for the properties to have.
Well, the staff report makes reference to it in the inspection.
So was it 12819? I mean, let me ask staff, was a franchise granted to which property?
The franchise was granted to 12793, but it also mentioned that they were remodeling 12819.
So it applies to both?
Well,
So what?
it was mentioned in there that their plan was to move and expand to the 12819.
Did they have a date of when they were planning to move?
When was that? Well, you just mentioned, what day was that? Was it 2018?
In your franchise.
Okay.
agreement.
2018, right?
Okay,
Other than that, I
I'm gonna go
got
back.
everything else you said.
okay, go ahead.
That's all I got.
Briefly, Mr. Mayor. I think, Mr. Hassan, you said that there's some resolution. Do you have a resolution different than this one that's signed by somebody from the city?
Correct. It was
Where is
submitted,
that?
it was submitted at the hearing? Here.
Well, no, you said that you submitted all, your lawyer submitted all, can you find it in those documents?
You said that you gave a copy of everything that was submitted on January 29th to everybody.
There is no resolution with a different signature. No, there is no resolution like that.
But we don't have the records that we submitted at the time. We submitted them to you, and I didn't have my set.
Okay, but you understand that this hearing is a standalone hearing, and you're supposed to submit whatever you have here,
No, I understood this was an appeal of a prior hearing, and that whatever we submitted before would be part of the record.
no, I don't know what you mean by appeal. It's called an appeal in the municipal code, but it's not an appeal like you normally think of a legal appeal. You need to go read the municipal code about
I've
what
read
this
it.
hearing really is.
Yeah.
It's not an appeal, it's a de novo. They get to
It's
decide
not an
all on their
evidentiary
own.
hearing.
It's a de novo hearing. They get to decide all on their own. They're not going to confirm his or overturn his. They're going to hear all the evidence you have today, and they're going to make their own independent
Where's our
decision.
package that we submitted the last time?
I don't have any duty to bring your packet. Where is it? You're the lawyer.
Yeah, well, we've submitted it to you for a specific purpose of creating a
You
record.
submitted it the last hearing. Now, this is a new hearing, and you know, if you read the municipal code, all the evidence has to
Shannon
be
has
put
it.
into this hearing.
Yeah.
So all the stuff for the last hearing isn't even going to count.
But you're asking my client whether he has another form of resolution that does not include those items. He says yes, and it was submitted at the last hearing.
Do you have anything to submit at this hearing?
We don't have that resolution now. Another gotcha rule thing.
Well, every time you do something wrong, you say, got you. But okay,
You have it already.
you're the lawyer. You're supposed to bring this stuff. You know that.
I brought
Shannon
it.
has it right there. I don't. No, I don't have it. So everything.
I have the resolution that he has.
January 29th, magically disappeared?
I don't have a resolution that differs from that.
Okay. Secondly, you say that you read out section U, I believe in the conditional use permit, but it wasn't exactly how you read it. What it says is the use shall be permanently removed from the subject property within a period of 5 years following the date of the approval of this resolution, except that prior to the expiration of this time frame, the applicant may request from the Planning Commission extension of the provisions of this conditional use permit, and that the grounds for denial of subsequent extension shall be, and it gives the 2 grounds for denial. So my question is, did you request from the Planning Commission an extension of this conditional use permit?
I was never notified to you.
Did you request an extension from the Planning Commission?
He's
So
not
since
the-
you were never notified, you didn't do it, right?
And he's
I'm
also
the
not
landlord. I'm
not
the
the owner.
tenant.
Okay, so this is your hearing. Did you submit any request for an extension of this conditional use permit?
I'm not the landlord of 12793. How can I possibly submit for something I don't own? That CUP is attached to the 12793 property.
No,
It's
the-
not attached to Hadley Toe. I moved in 5 years after that CUP was granted.
I understand. So you have not requested any extension,
I
right?
was never notified to do so. All I got is my business license renewal. I filled it out and sent it back in.
Okay, I'll accept that as a no. For 5 years. This CUP was good to 2008. You understand that, right?
Well, it was issued in 2001, so that
Well,
was
It was issued in
2003.
2003, January 22, 2003. It was good for 5 years, right?
correct.
Okay, you have no knowledge of anybody issuing an extension?
No.
Is that right? Now, at the last hearing, you and your counsel said that you were in substantial compliance with A, B, C, and E. Do you recall that? A, B, C, and E?
We don't have our notes from our last hearing. You said we don't have.
Well, I gave you the minutes. earlier.
Today, for the first time, sure.
Yeah.
Without advance opportunity to review them.
I'm going to go down the list on those. Can I do that?
Yes, sir.
Okay, so you know what? Let me first of all just begin by saying I am very disappointed with the outcome of this particular hearing. For one, I sat with you and you showed me a rendering that I'll tell you, and I even complimented. Wow, this is going to make that neighborhood look really good. The unfortunate part is that you I've never even actually seen the submittal of that actual rendering that he provided at that specific time. I'm very disappointed. That right there, my friend, would not be tolerated in West Covina, nor in the same neighborhood that you live in. This project right here, I'm extremely disappointed, because you have not really done much to improve it. You have barbed wire around that whole area. I don't. Is that permitted? First of all, to have barbed wires in those
Doesn't
areas?
have barbed wire.
Okay.
Get a street view of that image on Garvey, what
Okay.
it was before and what it is today.
Well, let me just tell you, you have not. First of all, you're out of compliance, and I'll tell you that right now. I'm extremely disappointed with that. Make that very clear. This is not the same concept that you provided to me and the council. This is totally.
It
Now
is
look at
with the
this.
exception of the building.
Okay, well, just look at this. First of all, the fire itself, 2014 and 2017. Am I correct?
No.
Okay, what was the dates that when they had the
It was on
actual
New
fire?
Year's Eve, so I don't know if it fell before midnight or after midnight.
But what year? What year?
I don't have the final
It
plan.
was before he was issued the
Okay.
2016
Well,
CUP.
Well, just say this is 2019. This is 2019. I personally don't believe that he had plans or making any immediate improvement, and it so happens because yes, of course, we brought it up to your attention. And again, this would not be permitted in West Covina, would not be permitted in Covina, would not be permitted in Amani, and of course, those days have been over in Baldwin Park many, many years ago. Because this right here, my friend, is unacceptable to me. So what I want to, first of all, begin, and first of all, as you mentioned to Councilman Vice Monica Garcia, you don't plan on going anywhere, and I don't want you to go anywhere. What I want you to do is comply with the ordinance that represents the city of Baldwin Park. So I'm going to go one by one through this item. And first of all, I want to make sure that, let me know if you complied with the CUP or not, and if you turned in all the material needed for this particular topic. First one is item A, that the property shall be developed and maintained in substantial accordance with Exhibit A to the staff report for CP 836 dated August 24, 2016. So at this point, I will ask you, did you comply with the CUP? Yes or no?
Repeat the question.
Okay, I'll read it off. That the property shall be developed and
Which
maintained.
CUP are we looking at?
We are looking at the CUP for, is this for the?
12819.
Yes, sorry about that. Yeah, 12819. Okay, so I'm going to read it again. You can follow me on this. Because
We're
I want to
talking
make
about 12819, which is not part of the franchise.
Well, wait a minute.
Legal
Let me
counsel?
correct that,
Yes.
Mr. Mayor. Mr. Evans keeps saying this is not part of it, and he is correct in a sense that he
Thank you.
applied for 12793. However, his agreement says that it can be revoked, suspended, or canceled if the franchisee breaches any rules, regulations, or conditions set forth in this franchise agreement or the Baldwin Park Municipal Code. So if they're breaking any rules at 12819, they still have a problem with their franchise.
That's
at
not a
127.
reasonable
Okay,
construction.
so at this
I
point,
know he disagrees, but
Okay,
that's what
I'm
this
going to
is.
read. I'm going to read it all the way through, and your answer: did you comply with the CP? Do you have the substantial information submitted to the city council? Let me
What
begin
CUP
again.
are we looking at again?
We are looking at CP 12819. Excuse me.
I'm sorry.
All right. Yes.
Repeat the address. one
Okay.
more
The
time.
address is 12819. So at this point,
Hold on, where are you looking at?
to look at this one right here, which is this Hadley towing. Yeah, at the top it says 16 to 18. I'm going to read them every, so this way we all have a very clear picture.
16, 18?
Yes.
And then what are you looking at?
Okay, what I'm going to go, I'm going to read A through all the required ones. I want to read them. I just want to make sure if they comply. I want to let them know yes or no. Have they complied with the CUP, and have they submitted the information necessary to be able to for this particular topic? Are you on there?
Yes.
Okay, so let me go through it. Okay, I'm going to read it. You there?
Yes.
All right, because now we're going to be here all night. Okay, item A, that the property shall be developed and maintained in substantial accordance with Exhibit A to the staff report CP 836 dated August 24, 2016. So at this point, have you complied with the CUP? Yes or no?
Substantial compliance.
You have?
My answer is substantial compliance.
Yes.
He says that he's in substantial
Okay.
compliance.
Okay. So alrighty.
The CUP requires compliance.
Compliance.
He's saying he's in substantial.
Okay,
The
that's
word
fine.
substantial is used actually in A. It says in substantial accordance, which doesn't require perfection.
Okay, item B, that the use shall be operated and the subject property maintained in neat and orderly manner and the site shall be kept free of litter, and that all graffiti throughout the property shall be removed within 24 hours at the expense of the applicant and or the owner.
Yes.
Okay. Item C, provide a video camera surveillance system as required by the city police department. Proposed surveillance system and placement shall be submitted to the city's police department for review and approval. Yes or no? And that's C. Yes or no?
I do have some cameras, yes.
Okay, so some. So partial.
Correct.
And approved
And
by
did
the
you get
police
approved by the
department?
police department?
Has it been approved by the PD?
I don't know.
Okay. All right. Then we'll check. We'll check with the PD.
Well,
He
he's right
said-
here.
Lieutenant, has it? Okay, has not. So there's a no for item number C. That has not been approved. All right, so then we'll go to item D. Provide rooftop numbering to be installed in accordance with the city's police department policy on the structures. Yes or no? Item D.
No.
Okay. All right, so item E, any and all landscape areas within.
Mayor, if I could back- okay.
Yes.
He lost the number of the fire.
Correct. Yeah. Just got substantial on that, right? That's,
So
Maybe that is done.
he had it, but he lost it.
no. Okay. All right.
I
Well, okay, that's for the record. So let me go back to E. Any and all landscape areas.
I'm sorry, Mr. Mayor.
Yes, sir.
Just remember the time frame of when the fires occurred.
Yes.
It was
So,
before.
before the CUP.
Oh, okay. Okay. Thank you for it.
So, yeah.
Okay. All right.
The
So
second
yes.
fire was after, wasn't it?
No.
Thank you,
No,
thank you
not
for that
according
point.
to what you
Thank you.
said earlier.
Okay, any and all landscapes areas within the site shall be automatically and maintained, okay? So at this point, E?
Automatically irrigated.
Yes.
Yes, automatically, yes?
Yes, we do have
Any and
irrigation.
all.
What's that? What's that,
He says-
Shannon?
He says
Any
yes.
and all, right?
So all the landscaped areas are automatic irrigation?
Yes.
Okay. He says
Okay,
yes.
all right, okay. Okay, F, that the applicant shall comply with and maintain compliance with the city's National Pollution Discharge Elimination, so known as NPDES requirements. Yes or no in this area?
I'm not sure I can answer that. I would have to ask my architect or the contractor.
Well,
So at this
Sam's
point,
right here.
Sam, can you?
That is the water quality plan.
Okay.
Personally, so the answer is no.
No? Okay.
Hold on, Mr. Son, is that, do you agree with that?
Yes, no.
So it's a no.
Okay,
Mr. Son.
all right, thank you. Item G, that the applicant is prohibited from causing or allowing deposit or disposal of any hazard substance at the property. The applicants shall be responsible for and bear the entire cost of removal and disposal of hazardous substance introduced to the property in compliance with the governing law. The applicant shall also be responsible for any cleanup and decontamination on or off the properties necessitates by the introduction of such hazardous substance. The applicant shall indemnify, defend, and hold the cities harmless from against and all liabilities, damages, claims, losses, costs, or expenses, including without limitations attorney fees incurred by or brought against the city in connection with or arising out of the use, storage, disposal, release, or other presence of hazardous substance on, in, or under, or about the release property. The phrase hazardous substance as used herein has the same meaning as the phrase under section 25359.7 of the California Health and Safety Code. So this one?
We all agree that has been complied with, Mr. Mayor,
Okay,
along
so-
with H, I, the next one for the
Okay,
council.
so hold on. So which? Okay, so the compliance with G. Did you say J as well?
J is the next one to consider.
G, H, and J.
Hold on. Legal counsel. Hold on.
The H part of it?
So
Which is the license plan.
okay, no, H is not part of this one.
No, H is not on.
H is not a part. So let's go to J. I'm going to go over to, so G was yes, so we're going to go over to J, which is provide a SUSMP is submittal repartee by the registered civil engineer in the state of California as qualified SWPPP prepared. So is this in compliance? So this is item J.
No.
No. Alrighty. So item K, submit grading plans, SWPPP, erosion control plan, and include low impact development standards for storm drain pollution protection. Has this been?
No.
Okay, no on this one. All right, so then we'll go down to letter R. So we're going to go over to R, which is to plant 5 trees on Westcott Avenue and three on Garvey Avenue per the city tree master plan. Irrigate 3 wells and maintain improvements. Has this been complied with?
No, and this is one of the items that wasn't on the resolution that I have that I reviewed with Amy at the planning department, which I submitted to Mr. Tafoya on January 29th.
But this was on the CUP, though. Am I correct? It's on the CUP.
Not on the resolution that I received from the city.
But it was on the CUP, I'd imagine. Am I correct? Am I wrong? Hold on.
We're on file with the city, the CUP that controls this issue.
Right. Okay. All right. All right. So now make sure that we provide them a copy. So we're going by the actual CUP.
So ours are not right?
Yeah. So R is basically no. Okay. Item S: install 2 street lights on Westcott Avenue per city street lighting master plan. Has that been complied?
No.
Okay. All right. Item T, which is to remove any unused driveway and replace with full height curbs, gutter, and sidewalk. Has that been complied?
No.
Okay. No. So at this point, I mean, we're definitely, yes.
That is the one CEP, Mr. Mayor, and then
Yes, sir.
if you want to ask questions about the second one, whether or not you got an extension to the 2008 CEP, I already asked Sam, but if you want to go over that one, you can.
Where's that one at?
Well, you already asked him about that.
Okay, fair
But
enough.
that one's
You
pretty
covered
much
that.
answered. That,
Yes, we
yeah,
covered
that's
that
fine.
one.
So you know what? So again, I mean, you're not in full compliance here when you're looking at this whole particular thing. I mean, I think you were given a fair opportunity to comply with this particular CUPs, and I personally, I really don't understand. And again, I think that for me, the disappointment that we have in the past dealt with, and Councilman Ricardo Pacheco, that we were not going to tolerate where businesses come in here and simply plant themselves and not comply with various types of ordinances that the city has. And you know what? At this point, I cannot support, and I'm just going to go and make the motion that I would like to make a motion to cancel the franchise agreement with Told based on the documents that were presented at the hearing, all testimonials at the hearing, all information provided this hearing, and the public documents available for review regarding this issue. A written opinion will be sent to you by the city attorney regarding the city's decision. So that is my motion.
I need to make a comment.
Hold on one moment. Okay, I made my motion. Is there a second?
Based on the gestures tonight, I'm going to second that.
Okay, there's a second. Are there any objections?
I object because
Okay,
I
no,
want to
excuse me,
respond
sir.
with-
No, you're not the voting body. Excuse me.
I have
See,
not
let me,
finished my
please
presentation.
stop, please.
I have not finished
Excuse
my
me, stop.
presentation.
Please stop. Okay, so at this point, I made a motion. It's been seconded by the Vice Mayor Baldwin Park, and there are no objectives. So at this point, the actual public hearing itself was just read and recorded. So at this point, legal counsel, you have the floor.
Well, you didn't allow me to make a presentation on that issue, and I have to respond this way. My client is not in violation of any code. He is not operating a business in violation of any zoning requirements. At 12819, he is not operating a towing business. He cannot possibly be in violation of a code or a requirement because he is not operating there. Until at such time that he does comply with the CUP, he cannot operate there. So saying that you're disappointed that he's not complying with the CUP, in an abstract sense, I understand that, but in the context of trying to cancel his franchise by saying he hasn't complied with the CUP, that is absolute nonsense. He is not violating any laws by failing to comply with the CUP when he is not operating a towing company. If he was operating at 12819 without a valid CUP, yes, that would be a violation. But simply falling short is his own problem because he cannot transfer the business from 12793 to 12819 until he is in compliance. So the concept that, well, if he hasn't complied with the CUP at 12819, we can cancel his franchise because he's not in compliance, that would be true if he was operating a towing company there. He is not.
Okay, so at this point, legal counsel, you will be forwarding the letter with the actual violations themselves that were in non-compliance with the CUP. Am I correct in that?
That is correct.
Okay. All right. So at this point, council members have any further questions? If not,
Mr.
yes,
Mayor,
go
so
ahead.
there was a motion and a second,
Yes.
and you asked for no objections, and then
That's
Mr.
right.
Evans
Yes.
said.
We'll know for the record.
You finished it for your vote? Your vote's finished?
That is correct.
Okay.
That's correct. All right, so at this point, unless we have anything else, I'll go ahead and move for adjournment of the special meeting. That is my motion. Second by Vice Mayor Monica Garcia. Any objections? Seeing none, so moved. Viva Ballpark. Good evening, everyone.